may be thinking to yourselves that I'm making this up, that the military who is sworn to support and defend the Constitution would not establish barriers to the due process protections guaranteed by our founding fathers. Lieutenant General Richard C. Harding revealed his guidance to all Air Force judges that victims are to be believed and their cases referred to trial. To date, the Department of Justice, Congress, nor this committee have conducted a deep dive to investigate this top federal prosecutor, investigate who gave the order to this top federal prosecutor, investigate if other top federal prosecutors from the Navy or Army provided similar orders, or investigate the secondary effects of this unlawful order on court-martial convictions. In April 2015, contrary to my pleas, with no physical evidence I committed a crime, a judge-alone panel convicted me of sexual assault and other related charges against my wife and sentenced me to 42 months in prison, even though I testified in my own defense. I never committed these crimes, even though I was never arrested, even though my previous command affirmed their investigation concluded I never committed a crime against my wife, and even after civilian police officers also testified at my trial that there was no evidence I committed any crime against my wife. To be clear, I was never arrested, had custody of my child up until my conviction, and the Florida District Attorney refused to prosecute me, yet a military judge alone found me guilty. Adding injury to insult, prior to trial, my wife offered a bribe that if I gave her full custody of our daughter, that she would forgo testifying at my court-martial. I declined her offer and presented this evidence to my convening authority, but with this overwhelming evidence to show my wife's motives for fabricating accusations for custody of our daughter were ignored. It gets worse. After trial, it was also discovered my mother-in-law paid the man my wife had an affair and child with $100,000 prior to his testimony on his relationship with my wife. I was awarded a post-trial hearing to evaluate the $100,000 payment and its influence on testimony after U.S. Congresswoman Martha Roby submitted a congressional to the Air Force. Citing court-martial rules, the Air Force responded to Congresswoman Roby, stating that the military judge had full authority to order a new trial or dismiss the charges. But at the post-trial hearing, when my wife, her boyfriend, and mother-in-law perjured themselves about the payment and the affair, the Air Force reneged on what was told to Congresswoman Roby and refused to allow my attorneys to file a motion for a new trial, stating the judge was not authorized because the record of trial was previously authenticated. So not only did the Air Force snub court-martial rules on the judge's authority at a post-trial hearing, they also violated federal rules under Brady by not submitting to my attorney what they affirmed to Congresswoman Roby. And by not allowing me to file a motion for a new trial, the Air Force presumably misled and provided a false statement to Congress. The Air Force closed ranks during my appeals, going against their own case law on authentication and the judge's authority at a post-trial hearing, even appearing to have influenced the Air Force Board of Correction for Military Records, because the BCMR, which is called, ruled that it does not have the authority to remedy a wrongful court-martial conviction and that they are only authorized to provide relief on a sentence, even though the law at 10 U.S.C. 1552 clearly provides authority for the BCMR to correct a wrongful court-martial conviction. You may be thinking to yourselves that I'm making this up, that the military who is sworn to support and defend the Constitution would not establish barriers to the due process protections guaranteed by our founding fathers. Unfortunately, this is not the case because in 2017, reports from the Department of Defense Judicial Proceedings Panel concluded the military indeed doesn't interfere with the lawful investigation, prosecution, and defense of sexual assault cases. In fact, the findings were so grave from these 2017 reports, I filed a human rights complaint to the Inter-American Commission for Human Rights, which I submitted to this committee for inclusion on the record. Findings from this report include the military prosecutes cases with no probable cause, which conflicts with the standards from the American Bar Association. In the military, there's no such thing as an alleged victim. All accusations substantiated an assault actually occurred.